The New York civil fraud case has become a landmark moment in United States legal history, where a court officially declared that a former president engaged in persistent and repeated fraud in his business dealings. Judge Arthur Engoron used very clear and unambiguous language in his ruling when he stated that the financial statements submitted to banks and insurance companies were materially false and deliberately misleading. The important thing to understand here is that this is no longer an allegation or accusation, but rather an official court finding that has been permanently documented in the legal record and cannot be disputed as mere political attack. This case was initiated by New York Attorney General Letitia James, who filed this lawsuit after years of thorough investigation. Her team analyzed hundreds of thousands of documents and clearly demonstrated that the Trump Organization had consistently and dramatically inflated the value of its properties. This means that whenever they needed to obtain loans from banks or secure insurance policies, they would show their assets to be worth far more than their actual value in order to obtain better terms and lower interest rates, which gave them an unfair advantage over other businesses operating honestly. Consider the example of the Mar-a-Lago estate, which was valued at roughly $18 million for tax purposes, but was shown in financial statements to be worth as much as $739 million. This gap is so massive that it cannot be explained away as a simple accounting error or a difference of professional opinion. This kind of discrepancy is only possible when someone deliberately manipulates the numbers to serve their own financial interests. The judge specifically highlighted this point and noted that this pattern was not a one-time occurrence, but rather repeated consistently across multiple years and multiple properties. From the perspective of the banks, this is an extremely serious matter because when a borrower provides false information about their financial health, the banks cannot properly assess their risk. If the banks had known that the actual asset values were so much lower, they might not have approved the loans at all, or they would have charged significantly higher interest rates to compensate for the increased risk. By misrepresenting this information, the Trump Organization obtained an unfair advantage which technically falls within the legal definition of fraud. Deutsche Bank, which was the primary lender to the Trump Organization, has internal documents that confirm the information provided to them did not match the ground reality. The case with insurance companies follows a similar pattern. When you overvalue your properties to obtain insurance, you are essentially obtaining higher coverage than you are entitled to receive. This falls under the category of insurance fraud, and in this case, the court specifically noted that multiple insurance applications contained inflated values that did not reflect actual market conditions or independent appraisals. Now, there is an important legal distinction that must be understood here. This case was civil in nature and not criminal. In a civil case, the government or plaintiff must prove that wrongdoing occurred, but the standard for proving intent or criminal mens rea is not as strict as it would be in criminal proceedings. This is precisely why the outcome of this case involves monetary penalties and business restrictions rather than prison time. The judge ordered approximately $355 million in disgorgement penalties, which essentially represents the profits that were earned through the fraudulent conduct. Additionally, both Trump and his sons have been temporarily banned from serving in leadership roles in any New York company. However, the broader impact of this civil finding is extremely significant for several reasons. First and foremost, it is now officially on record that fraud has been proven in a court of law. Second, this finding can potentially be used by special counsel Jack Smith in his federal criminal cases as evidence of a pattern of deceptive behavior and character. Third, banks and financial institutions will be hesitant to deal with the Trump Organization in the future, which will severely impact their business operations going forward. Deutsche Bank has already terminated its relationship with the Trump Organization, and according to multiple reports, other major banks are also maintaining distance. This financial isolation is extremely damaging because the real estate business is heavily dependent on bank financing. Without proper banking relationships, it becomes almost impossible to execute large-scale projects. The court documents also revealed that accountants and appraisers played a role in these inflated valuations. Mazars USA, which was the accounting firm for the Trump Organization, publicly terminated their relationship and stated that the financial statements they had prepared should no longer be considered reliable. Special counsel Jack Smith is handling two entirely separate federal criminal cases against former President Donald Trump, and it is crucial to understand that these cases have absolutely nothing to do with the New York civil fraud case that we discussed earlier. While the civil case dealt with inflated property values and financial misrepresentation, the federal criminal cases deal with matters of national security and the integrity of American democracy itself. Jack Smith was appointed by Attorney General Merrick Garland specifically to ensure independence and impartiality in prosecuting these highly sensitive matters involving a former president who is also a current presidential candidate. The first federal criminal case involves the mishandling of classified documents at Mar-a-Lago Estate in Florida. After leaving the White House in January 2021, Trump took hundreds of documents with him to his private residence. Many of these documents were marked as classified at the highest levels, including top secret and sensitive compartmented information, which means they contain some of the most closely guarded national security secrets of the United States. The National Archives repeatedly requested the return of these documents, and after months of back and forth, Trump returned some boxes, but the government believed more documents remained. This led to an FBI search of Mar-a-Lago in August 2022, which recovered over 100 additional classified documents from various locations throughout the property, including a storage room and even a bathroom. The indictment alleges that Trump not only retained these documents illegally, but also obstructed government efforts to retrieve them. He allegedly directed employees to move boxes to hide them from investigators, and his attorneys reportedly made false statements to the FBI claiming all classified materials had been returned when they had not. This obstruction element makes the case significantly more serious because it suggests consciousness of guilt and deliberate efforts to impede a federal investigation. The charges in this case include willful retention of national defense information under the Espionage Act, as well as conspiracy to obstruct justice and making false statements. If convicted on these charges, Trump could face decades in federal prison. The Espionage Act charges alone carry potential sentences of up to 10 years per count, and with over 30 counts related to individual classified documents, the theoretical maximum sentence is extraordinarily severe. Legal experts note that while such maximum sentences are rarely imposed in practice, even a fraction of that time would represent significant prison exposure for a former president. The second federal criminal case relates to the efforts to overturn the 2020 presidential election results culminating in the January 6, 2021 attack on the United States Capitol. This indictment alleges that Trump engaged in a multi-pronged conspiracy to remain in power despite losing the election. The alleged scheme included spreading false claims about election fraud, pressuring state officials to change vote counts, creating fake slates of electors in key swing states, pressuring Vice President Mike Pence to refuse certification of electoral votes, and ultimately inciting the mob that attacked the Capitol building. The charges in this case include conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an official proceeding, and conspiracy against the rights of citizens. These are extremely serious federal charges that go to the heart of American democratic processes. The obstruction charges alone carry potential sentences of up to 20 years in prison. Prosecutors have extensive evidence, including text messages, emails, testimony from White House insiders, and Trump's own public statements and tweets from that period. Now, here is where the connection between the cases becomes analytically important, even though they are legally separate. Both cases demonstrate what prosecutors might characterize as a pattern of behavior, where rules and laws are viewed as obstacles to be circumvented rather than boundaries to be respected. The civil fraud case showed a willingness to manipulate financial records for personal benefit. The classified documents case allegedly shows a willingness to ignore national security protocols for personal reasons. The January 6th case allegedly shows a willingness to undermine democratic institutions to retain power. Jack Smith and his team are experienced federal prosecutors who have handled complex international cases, including war crimes and public corruption. They understand the historical significance of prosecuting a former president and the extraordinary burden of proof they must meet. Every piece of evidence must be meticulously documented, and every legal argument must be bulletproof because these cases will face intense scrutiny from defense attorneys, appellate courts, and the court of public opinion. The question of whether a former president of the United States could actually go to prison has shifted from theoretical speculation to genuine legal possibility, and this represents an unprecedented moment in American history. To understand why prison is now a realistic outcome, we must first understand the fundamental difference between civil and criminal proceedings in the United States legal system. In civil cases, the remedies are typically monetary penalties, restitution, or injunctions that restrict certain behaviors. In criminal cases, however, the government seeks to punish wrongdoing through incarceration, probation, or other penalties that directly affect personal liberty. This distinction is absolutely critical when analyzing the legal jeopardy facing Donald Trump. The New York civil fraud case, despite its dramatic findings and massive financial penalties, could never result in prison time because it was designed as a civil enforcement action from the beginning. Attorney General Letitia James brought the case under New York Executive Law, Section 63-12, which authorizes civil remedies for persistent fraud. The $355 million penalty is certainly severe, and the restrictions on business operations are significant, but at no point was imprisonment ever on the table. This is why critics who focused only on the fraud case sometimes underestimated the overall legal exposure, because they were looking at a case that by its very nature could not produce a prison sentence. The federal criminal cases brought by special counsel Jack Smith operate under entirely different rules with entirely different consequences. When the federal government brings criminal charges, it is seeking to deprive a defendant of their liberty through imprisonment. The charges in the classified documents case carry extraordinarily severe potential sentences. Willful retention of national defense information under the Espionage Act carries penalties of up to 10 years per count. With over 30 individual counts related to separate classified documents, the theoretical maximum exposure exceeds 300 years. Obviously, no court would impose such a sentence, but even if a judge imposed just a small fraction of the maximum, the result would still be significant prison time. The obstruction charges add another layer of serious exposure. Obstruction of justice in federal cases typically carries sentences of up to 20 years per count. When prosecutors can demonstrate that a defendant not only committed the underlying offense, but also actively worked to hide evidence, deceive investigators, and impede the legal process, judges tend to impose harsher sentences. The allegations that boxes were moved to conceal documents and that attorneys made false statements to the FBI suggest exactly this kind of aggravating conduct that prosecutors emphasize at sentencing. The January 6th election interference case presents similarly severe sentencing exposure. Conspiracy to obstruct an official proceeding and obstruction of an official proceeding each carry maximum sentences of 20 years in federal prison. Conspiracy to defraud the United States carries a maximum of 5 years, while conspiracy against rights carries a maximum of 10 years. When these charges are combined, the total theoretical maximum easily exceeds 50 years. Again, while maximum sentences are rarely imposed, the statutory framework makes clear that Congress viewed these offenses as extremely serious threats to the functioning of democratic government. Federal sentencing in the United States follows guidelines established by the United States Sentencing Commission. These guidelines consider factors such as the severity of the offense, the defendant's criminal history, acceptance of responsibility, and various aggravating or mitigating circumstances. For a first-time offender, which trump technically is the guidelines, would suggest sentences below the statutory maximum. However, the guidelines also account for abuse of position of trust, obstruction of justice, and the scope of harm caused. A former president mishandling the nation's most sensitive secrets or attempting to overturn a democratic election would likely face significant enhancements under these factors. There is also the question of whether any conviction would actually result in imprisonment given the appeals process and potential delays. Federal appeals can take years to resolve, and a defendant typically remains free on bail during this process unless they pose a flight risk or danger to the community. However, once appeals are exhausted and convictions are affirmed, defendants must report to serve their sentences. There is no special exemption for former presidents, and the Constitution provides no immunity from criminal prosecution for actions taken outside official presidential duties. The Supreme Court has never directly addressed whether a former president can be imprisoned, but nothing in constitutional text or precedent suggests they cannot be held accountable like any other citizen.